everybody. With Chapter 8, we're looking at crime and mental health issues. The first thing I want to say about this is the vast majority of people with mental health issues never commit a crime. Um, Really, most people with mental health issues are more of a danger to themselves than they are to other people. Having said that, let's move forward and talk about mental health issues and those that can lead to criminal behavior. So, first of all, mental illness is a disorder of the mind that is judged by experts, psychologists, and psychiatrists, in this case, to interfere with a person's ability to cope with life on a daily basis. The term mental illness, mental disorder, those are interchangeable. It's a little bit less restrictive to say mental disorders, but really they're both interchangeable. They both suggest that somebody has some pattern of behavior that is, problematic for them. It's interfering with their ability to be happy, to live, to work, to have relationships. Or it's getting them in trouble with the law somehow as well. An intellectual disability is a development or intellectual cognitive deficit of some type, usually measured by IQ. 70 or below in terms of IQ is the legal cutoff, according to the American Psychiatric Association, for having a intellectual disability. Now, how we diagnose mental illnesses, and I've referenced the DSM before. It's the Diagnostic and Statistical Manual. It is published by the American Psychiatric Association, currently in its 5th edition. It is the guidebook for clinicians to look at the criteria for a specific diagnosis. If you look up a disorder, it has the criteria that would be needed to diagnose somebody with a particular mental illness. Mental disorders that are most likely to be associated with criminal conduct. These disorders are more likely to end in some type of contact with the criminal justice system. So the ones that we're going to look at today include schizophrenia, bipolar disorder, depression, and antisocial personality disorder. We've talked a little bit, particularly in our last chapter, about antisocial personality disorder, and it's probably the one that we need to worry about with the most when we talk about somebody that is a criminal psychopath in terms of engaging in criminal behavior. So let's start with schizophrenia. Schizophrenia is a mental disorder where there is often bizarre behavior, hallucinations, delusions, and technically it is not split personality, it is a split from reality. Their thinking is often very disorganized. Sometimes their speech is disorganized. They're hard to understand. They have abnormal motor behavior, the way that they move their body. They often have problems with emotional responses, like flat affect. Remember, affect means emotion. So kind of flat or abnormal affect. The proportion of violent crime is small, but the level of violence can be high, particularly if somebody with schizophrenia believes that they are hearing voices or seeing something, or believe that they are being threatened in some manner. Bipolar disorder is a mood disorder. It is when a person has swings of their mood. Bipolar disorder, you swing from having a manic phase, which is really high energy, euphoria, really distracted, kind of all over the place, not a lot of sleeping, high sex energy. People engage in a lot of drug and alcohol use in this manic phase. And then it swings over to a depressive phase where we would see really clinical depression, diminished interest in activities, depressed mood, changes in weight and appetite. And it can lead to reckless behaviors and risky behaviors that could cross over into criminal behavior, particularly on the manic phase. Not so much in the depressive phase, but when we see the manic phase, where we could see risky behavior. There is also a lot of drug and alcohol use with mood disorders, particularly bipolar disorder. So that could also cross the line into criminal behavior as well. Major depressive disorder. This is being extremely depressed for at least 2 weeks. And clinical depression can affect every aspect of functioning. That includes thinking, behavior, um, sleeping, eating. So it really is a slowing down of all mental and physical activity, gloom, despair, feelings of worthlessness, hopelessness, can have frequent thoughts of suicide, even attempts with suicide. Now, when it comes to depressive disorders like bipolar disorder or clinical depression, by the way, is often called in psychology the common cold of mental disorders because it occurs so often. Um, when we talk about mood disorders, it includes bipolar disorder, major depressive disorder, also SAD, that's seasonal affect disorder. That's people who are really depressed, generally in the winter in northern hemispheres where they don't have a lot of sunlight. With major depression, you have these symptoms, and they have to last longer than 2 weeks to be diagnosed, but it affects your thinking, your physical activity, your emotions, your mood, includes, again, those feelings of hopelessness, helplessness, despair. Depression is strongly associated with delinquency, especially in girls. And by the way, depression affects women at a rate of 2 to 1 over men. Depression in teens seems to render them indifferent to what happens to them. And if you are indifferent, that can lead to risky behavior, particularly if you don't care what happens to you. Depression also seems to play a role in other crimes like mass shootings, school shootings, workplace violence, and suicide by cop. So those would be other criminal behaviors that we would see associated with depression. All right, we talked about antisocial personality disorder, APD. It is a personality disorder characterized by a history of continuous behavior in which the rights of others are violated. We talked about psychopathy, which often goes along with antisocial personality disorder. The hallmark of this disorder, as we mentioned previously, is really that lack of empathy, sympathy, guilt. You don't feel guilt, remorse, or shame. You're just void of that. Impulsive, risky behaviors. We already talked about how you can't be diagnosed with that under the age of 18. You have to be 18 to be diagnosed with, with antisocial personality disorder. To be diagnosed, you have to have at least 3 of the following behavioral patterns. Number 1, failure to conform to societal norms or criminal laws, codes. Number 2, aggression, physical fights. Number 3, irresponsibility, poor work habits or history, impulsivity, failure to plan ahead, deceitfulness, lying, use of alias, conspiring against others. Number 6, reckless disregard for the safety of others or self. And number 7, lack of remorse, guilt. We've already mentioned that Hare and others who have done research in psychopathy and antisocial personality disorder suggest that anywhere from, depending on the study, up to 60% of the prison population would qualify for a diagnosis of antisocial personality disorder. I mentioned last week that as a personality disorder, almost all personality disorders are diagnosed more often in men than they are in women, and this is definitely one of them. So we would see this more often diagnosed in men. It's estimated that 3% of all men and 1% of all women have antisocial personality disorder. And remember, when we talked about psychopathy and antisocial personality disorder, not all people with this disorder or even with psychopathy will be criminal offenders. Some are just really, terrible humans, but they don't necessarily cross the line into criminal behavior. I do have in D2L a link on schizophrenia and a link on antisocial personality disorder, so you can learn more about both of those by going to those links and reading about those. All right, now this is another area when it comes to mental health issues and the criminal justice system. There are 2 issues that we are going to read about in this chapter. That is competency and criminal responsibility, and they are 2 very different issues. Competency is your mental state at the time of the criminal proceeding. So at the time you're going to trial, if you've been arrested. Criminal responsibility is your state at the time the crime was committed. So it's two different issues. The U.S. Supreme Court in Dusky versus the United States, and this was related to competency to stand trial, found that defendants are competent to stand trial if they have sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding and a rational as well as functional understanding of the proceedings. This can apply to mental disorders or to those who have developmental disabilities. So they have to have competence to be able to proceed, understand the proceedings and ability to work with one's attorney, number one. And number two, decisional competence, the ability to comprehend the significance of the various decisions to be made. Remember, when you talk about adjudicative competence, it's a term used by some instead of just regular competence, but this term relates to the ability to participate in a wide variety of court proceedings and court-related activities, like plea bargainings, entering in a guilty plea, hearings, motions, or even just moving forward with a trial. Competency can be brought up at any stage of the proceedings. So when somebody is just entering the court system, the trial system, that can be brought up as an issue. During the trial, it can be brought up as an issue. While a person is in jail, it can be brought up as an issue. So competency to understand what's going on and understanding the legal proceedings can be brought up at any time. Evaluations for competency to stand trial is the most common referral for criminally related forensic assessments by a clinical psychologist and psychiatrist. Most referrals are for people with a history of mental illness or obvious symptoms. Evaluations are typically done by psychiatrists. They can be done by clinical psychologists as well, but we do see a lot of these being done by forensic psychiatrists. About 25,000 defendants, or 1 in 15 each year, is sent for some type of competency evaluation, and about 4 out of 5 are found to be competent. So it doesn't really happen a whole lot that somebody is found incompetent. However, if somebody is found incompetent to stand trial, it kind of depends on what's going to, on how serious the offense is. So if the charges are not very serious and somebody is found incompetent, the charges might be dropped and a person would be sent off to a mental health facility for treatment. However, if it's a pretty serious case, then they'll have a hearing, and the judge can order the person to be put into a mental facility and treated. So in cases that involve violence, generally speaking, the charges won't be dropped. The person will be sent off to a mental health facility. The Supreme Court has ruled that you can be forced to take medication against your will if it will bring you back to legal competency. You have to have a hearing for that, but happens all the time where somebody is found incompetent to stand trial. They have a hearing. The judge sends them off to a mental health facility. They are forced to take medications after a hearing that bring them back to competency. And then once they are found to be competent, the judge will stay on top of that. Once they are found to be competent, they'll be brought back to the legal proceedings and then go ahead and continue with those legal proceedings. And again, we're looking at, just kind of remember that when we're talking about competency, we're looking at their state of mind at the present time, at the moment that the criminal proceedings are taking place. All right, not guilty by reason of insanity. When we're talking, and this is criminal responsibility is at the time that the crime was actually committed. So remember, these are two different issues. Not at the time of the legal proceedings, that's competency, the time that the crime was committed. So insanity is not a term that we use in psychology. It is a legal term. Insanity refers to a person's state of mind at the time the offense was committed. The judge or the jury must determine if a person was mentally disordered at the time a crime was committed and whether or not they were responsible for the actions. The law assumes that a mental disorder can rob a person of free will and or the ability to make good choices, understanding right from wrong. Now, if you're not familiar with the John Hinckley case, this was back in 1982. John Hinckley shot President Reagan and others, and he was found not guilty by reason of insanity and sent to a mental health facility. That really incensed the nation that he was found not guilty by reason of insanity, and because of that, in 1984, Congress passed the Insanity Defense Reform Act, making it more difficult to use not guilty by reason of insanity as a defense. Prior to this act, prosecution had to prove that a defendant was insane beyond a reasonable doubt. Now the defendant has to prove insanity by clear and convincing evidence. So the burden has shifted from the prosecution to the defense. It is really hard right now, since 1984, to effectively use not guilty by reason of insanity. 34 states have made changes to the laws since the Insanity Defense Act was passed in 1984, making it more difficult. About 22% success rate with this defense. Andrea Yates is a great example of this. If you're not familiar with the Andrea Yates case, Andrea Yates was a mother in Texas who drowned 5 of her children. And Andrea Yates had a long documented history of mental illness, serious mental illnesses. She'd been in and out of mental institutions. She suffered from postpartum psychosis, and that was documented. She had been on really strong antipsychotic medications like Halcyon, and had been warned by her doctors. Her family had been warned. Her husband had been warned. So she had a very documented long history of serious mental illnesses. The jury didn't buy it, and she was found guilty. That case was eventually reversed, and the second time she was found not guilty by reason of insanity, and she is now in a mental institution. But she's a great example of how difficult it is to actually effectively use not guilty by reason of insanity since the 1984 Reform Act was passed. So it's rarely successful. When it is successful, it is typically on people with something like schizophrenia, documented schizophrenia, or some type of other psychosis where somebody is hearing voices or having delusions or is kind of out of touch with reality. If somebody is found not guilty by reason of insanity, like Andrea Yates with her second trial, they will be sent to a mental institution until it is deemed by the mental institution and the court that they are no longer legally insane. People like Andrea Yates will be there for their entire lives, especially if it's a really violent crime. But that is the process. And again, it rarely works. Now, there's some history of insanity standards. And every state is different. And remember, all states can decide how their state courts are going to run. The Naughton Rule, this is one of the old rules from 1843 in the history of the laws. This was the right or wrong test, looking at the cognitive elements. Number 1, was the person aware, and did they know that what they were doing was wrong at the time? Knowing right from wrong in the legal sense is really what they are looking at here. So did the person understand that what they were doing was wrong at the time the crime was committed? The Browner Rule and the American Law Institute rules, largely based on the insanity rule suggested by the Model Penal Code proposed years ago, but this one, the Browner Rule, is from 1972. A person is not responsible for criminal act if at the time the act was committed, number 1, the conduct was the result of a mental disease or deficit, or number 2, they lacked a substantial ability to appreciate the criminality, wrongfulness of their behavior. The Durham Rule, this one is also called the product test. This is from a case in 1954, Durham versus the United States. An accused is not responsible for an unlawful act if it was a product of mental disease or deficit. The product test is based on testimony or opinion of psychologist or psychiatrist. This one not used very often, and particularly since the changes in the Insanity Reform Act, because after the Insanity Reform Act, Psychologists and psychiatrists are no longer allowed to get up and say, give an opinion on whether they think somebody was legally insane or sane at the time a crime was committed. They can talk about mental health history, they can talk about clinical diagnosis, but they cannot give an opinion. Again, the Insanity Defense Reform Act that was passed after John Hinckley shot President Reagan and others in 1982. This act was passed in 1984. A person should be found not guilty by reason of insanity if it is shown that as a result of mental disease or some type of cognitive deficit, he or she was unable to appreciate the wrongfulness of her conduct at the time the offense was committed. As I mentioned earlier, shift the burden of proof off of the prosecution and onto the defense, and psychologists and psychiatrists can no longer give an opinion on insanity, but they can talk about clinical diagnosis and mental health history. The mental disease or deficit defect must be severe. Certain behavior disorders and personality disorders don't qualify. Antisocial personality disorder, by the way, would not qualify. Psychopathy is not a clinical diagnosis. It would, as I mentioned earlier, have to be something really serious like schizophrenia, postpartum psychosis, like with Andrea Yates. And again, no opinions expressed by clinicians. Now, some states after the 1984 Reform Act came up with another option, which is guilty but mentally ill. So it's an alternative verdict adopted by some states, and it will vary from state to state. But it allows the person with a mental health issues to plead guilty. So they're accepting the blame, but instead of going to prison, they go to a mental health facility. So they are held accountable and blameworthy, but it recognizes that they have a mental disorder and allows them to get treatment instead of going to a prison. We don't really have a lot of treatment options in prisons for people with mental health issues, so that's a good option. Unique defenses, post-traumatic stress disorder. You've probably heard of this. PTSD is a anxiety disorder, often affects veterans. That's probably where you have heard it, most associated with people coming back from combat situations. But post-traumatic stress disorder can develop for anyone who has been in some type of situation where they felt like their safety and their life was in jeopardy. We see it with crime victims. We see it with people who have experienced natural disasters, been in car accidents, been in other really horrific accidents or witnessed horrific accidents. We see a lot of PTSD in child abuse, domestic violence. PTSD has been used to justify not guilty by reason of insanity for both violent and nonviolent crimes. Some people with severe PTSD do have a disassociative state where they kind of detach from themselves and lacked contact with reality. Remember, that's kind of what we associate with schizophrenia as well. So that's why this one would qualify. I mentioned Andrea Yates, and I talked about battered women. I talked about postpartum psychoses. And postpartum psychosis would involve a lot of these symptoms that we do see with post-traumatic stress disorder, along with being out of touch with reality. Also, battered women's syndrome, which is a form of PTSD, also an anxiety disorder, where a woman who has been battered repeatedly over time experiences a dissociative state and sometimes attacks or kills her abuser. Battered women's syndrome has been used successfully as a criminal defense with not guilty by reason of insanity. These things don't often work, but again, they are unique defenses and conditions that could be brought up as part of the history with not guilty by reason of insanity. By the way, dissociation is when a person kind of it is separated from themselves, so to speak. They don't remember what is going on. They don't remember what they did at the time. It can be part of severe disorders like postpartum psychoses, battered women's syndrome, PTSD, schizophrenia. There's also something called dissociative identity disorder. You probably have heard of this being called multiple personality disorder. This is what it used to be called, or split personality disorder. But it's called dissociative identity disorder, and this is when a person has two or more distinct personalities. This is a very rare and very controversial disorder. The vast majority of psychiatrists and psychiatrists are skeptical on whether or not dissociative identity disorder actually does exist, whether or not a person could have two or more distinct personalities. What happens with disassociation, regardless of why it happens, is amnesia. Amnesia is a partial or complete loss of memory of events, or it can be a series of events or even aspects of one's life. It can be due to actual physical trauma, like head injury, or psychological or emotional trauma. So, as a group, individuals who are mentally ill are no more likely to commit crimes than those who are not. They're more than 3 times higher in the criminal justice system population than in the general population, however. And that's unfortunate because, as I mentioned, within our prison systems, we don't really have a lot of mental health therapy. They do, people are legally entitled to treatment for mental health issues while being incarcerated. So they will be monitored for medications. So they do have psychologists and psychiatrists that either work at prisons or come in on a contractual basis to make sure that people are getting the medications and the things that they need for their mental health issues. All right, when it comes to research, individuals with schizophrenia are at an increased risk of violent offending and higher risk to commit murder. So if we had to pick a mental health issue where they're more likely to be of a danger to other people, it would be schizophrenia. It's very rare still, but they could be at a risk for committing murder and hurting other people. Men who have both schizophrenia and substance abuse problem are at an increased risk of violent offending as well. The MacArthur Research Network followed 1,000 patients discharged from psychiatric hospitals for a year. Patients were measured on 134 risk factors with this study while they were hospitalized, like violent fantasies, history of abuse. Based on the findings, they established a classification system for low risk, average risk, and high risk in terms of risk assessment and releasing offenders. So based on these risk factors and studying people for a year, they can now classify people before they're released as either being low risk, medium risk, or high risk for reoffense. Found those classified as low risk based on those factors did commit fewer crimes than those classified as high risk. With risk assessment, this is an interesting case. The Tarasov case is related to duty to warn and a duty to protect. This case came out of California in the 1970s. A young woman named Tatiana Tarasov was stabbed to death and killed by an outpatient at a Berkeley clinic. So there was a man who had been seeing a psychologist as an outpatient in a Berkeley, California clinic, and the offender had told his therapist that he wanted to harm this specific girl and that he had fantasies about it and that he had purchased a gun. Now, the therapist did notify the police, and the police did tell the offender to stay away from Tarasov, but they didn't do anything more. They didn't give her a protection of order. They didn't tell her that this man had purchased a gun and had made risks against her, so she didn't take any steps to protect herself. After that, and he did murder her. After that case, the California Supreme Court ruled that therapists have a duty to warn the person who has been threatened. So not only do they have the duty now to warn the police, but they also have a duty to warn the person who has been threatened. States vary on how they apply the duty to warn. Some require psychologists and psychiatrists, if a threat has been made, to just warn the police, and some require, like California, to warn both the police and the person who has been threatened. All right, police and people with mental health issues. Historically, police have often arrested those with mental illnesses and do not have really the training to recognize or understand mental health issues or recognize behaviors that are associated with mental health issues. Um, we find more training today, especially in larger jurisdictions. Um, which helps police determine whether or not somebody needs to be taken to jail or maybe they need to be taken to a hospital. Um, we also find that false confessions are more likely more likely to take place by people that have mental health issues. So this continues to be problematic. With interrogations, people with mental health issues also often don't understand their legal rights to counsel, their legal rights not to say anything or to ask for an attorney. So police are definitely encouraged that if it appears that somebody has a mental health issue, to stop and to bring in a psychologist to evaluate that person before they move forward. It actually behooves the police to do this because if they get a false confession, of course, that's no good for anybody, and they don't want any of their cases to be thrown out because somebody did have a mental health issue. Mentally disordered inmates. Research indicates that the percentage of mentally disordered inmates in the nation's jail and prisons is increasing. And as I mentioned, we don't have a lot of treatment in our prison system for people with mental health issues. A lot of time, people with mental health issues are held in a separate ward, like in supermax prisons or high security prisons, where they might be at danger. They're held in the ADSEG unit, which means that they are separated from the general population, which is good, but they're often housed in their cells for 23 out of 24 hours. So that's not good. Oops. Violent risk factors and measures. So when somebody's going to be released from prison, or maybe if somebody is, maybe if the courts are trying to determine whether somebody should be put into a mental health facility or to have the charges drop, they might have a psychologist or psychiatrist come in and do an assessment of risk to determine if a person is at risk of harming themselves or others. How psychologists and psychiatrists will do this is, number one, by having a clinical evaluation. And, it's probably going to take more than one meeting with a person. They might use what's called the actuarial approach, where they'll use a variety of assessments that have been developed for a different variety of offenders to determine if they are at high risk for reoffending or to be a risk to themselves of others. Most psychologists will use both. They will have clinical interviews, they will give some risk assessments to that person, and then make an evaluation that they will report either to the court or to the parties involved, whether or not they think that the person is at high risk for reoffending or hurting themselves as others. All right, so lots of links for this chapter in D2L. There's an article on schizophrenia, on antisocial personality disorder. You have a couple of different links and articles on competency to stand trial and legal insanity and in the insanity defense. And then there's a PDF document on criminal behavior and mental illness. So if you have any questions about anything in this chapter, let me know. Otherwise, have a great day.